We're resuming the hearing in the case of Re T, and I'm going to invite Ms. Clement for the Secretary of State to make her submissions now. Ms. Clement.
My Lady, I'm grateful. My Ladies, my Lords, I appear for the Secretary of State in this matter, together with my junior Ms Hannah Slarks. The Secretary of State's grateful for being given the opportunity to intervene in this appeal. The matters that are raised are obviously of importance and of importance for the work of his department. My Lady, we have divided up the submissions as follows. The respondent and the Welsh Government have agreed that the Secretary of State will address the court first on the points of principle raised in this appeal. I do not make any submissions on the facts of the appeal. Miss Weston, Queen's Counsel for the local authority, will address you on that. I do not make any submissions on the law as it relates to secure accommodation in Wales and the specific duties imposed on local authorities in Wales. Mr Hopkins, Queen's Counsel, will address you on that. My Lady, there are three preliminary observations I wish to make before I move to the main body of my submissions. The first is that the Secretary of State is aware of the concerns that have been raised about the shortfall of places in approved secure children's homes at particular points in time. The Secretary of State shares the concerns that have been expressed and is of the view that it is unacceptable for any child or young person to be placed in a setting that does not meet their needs and does not keep them safe. However, the question of how that issue is resolved is a complex matter, and what is required to best meet the needs of a small cohort of children within the care system with increasingly complex needs and or challenging behaviour is far from straightforward. And my Lady, I've set out at section C of our written case, for your note it's at page 348, paragraphs 44 to 53, the work that the Secretary of State and the Department has commissioned to investigate these matters. The Government is committed to carry out a review of the care system as part of its manifesto. The urgent response to COVID-19 has delayed the launch of this review, but the Government is committed to undertaking it as soon as possible, and I'm told that preparations are being made to launch that review. That review is going to take a fundamental look across children's social care, including residential care, with the aim of better supporting, protecting and improving the outcomes of vulnerable children and young people. My second preliminary point is that the duty to ensure that sufficient accommodation is available for looked after children in their area rests on local authorities. I've set that out in our written case at paragraphs 18 and 19, page 339, and that duty comes from section 22G of the 1989 Act. That is found at page 847 of the electronic bundle. The Secretary of State has provided statutory guidance on how local authorities should secure sufficient accommodation for looked after children. That is also in the bundle at tab 44. My Lady, the third preliminary is that the Secretary of State has very recently consulted on a series of proposals for reform for unregulated provision for children in care. For the court to note, that consultation document is at tab 126, page 5127. And the Secretary of State's proposals are set out in the introduction at page 5129, and we have summarised those proposals for reform at paragraph 51 and 52 of our written case at page 351 of the bundle. My Lady, I intend to structure my submissions as follows. I adopt my written case. I don't intend to go through in detail the statutory framework that I've set out in section B of that written case. It is there at page 334 of the bundle. The first matter I want to address is the first issue raised in the appeal, namely whether section 102D of the 1989 Act is a statutory bar to the use of the inherent jurisdiction. Next, I intend to take matters slightly out of turn and to address issue 3 that was advanced by the appellant this morning, to respond to the argument that the use of the inherent jurisdiction cuts across the statutory scheme. Then I will return to make submissions on Article 5 of the Convention and to address what the points made by the appellant this morning, and also points raised by the Children's Commissioner for England in her written submissions. And finally, I'll make a number of short points on ground 2 and the role of consent in cases of this nature. So, my Lady, turning to the first issue, and whether section 102B is a statutory bar to the exercise of the inherent jurisdiction. We say that it is not, and we say this for three reasons. First, we say this follows from the words used in section 102D itself. Second, we say this follows from a purposive interpretation of that provision when read against the admissible background materials identifying the mischief behind section 102. And third, we say in any event, the appellant is wrong to contend that depriving a child who is Gillick competent of her liberty is a matter that arises in connection with any aspect of parental responsibility. So turning to the first of those points, if we turn up section 102, it's at page 869 of the bundle. And we see the language itself. No court shall exercise the High Court's inherent jurisdiction with respect to children for the purpose of conferring on any local authority, the first aspect, power to determine any question which has arisen or which may arise, and then the last aspect, in connection with any aspect of parental responsibility for a child. And the starting point in this case, and in many other cases of this nature, is that the local authority already has parental responsibility for the child in question, in this case through the care order that was made, and that is obtained through section 33(3)A of the 1989 Act. For the court's note, that is at page 862. The local authority is also already under a duty to accommodate a child in care. That is section 22A of the Children Act, page 841. And the local authority is also under a duty to accommodate a child in care in accordance with section 22C of that Act. And that is found at page 843. The local authority is under a duty to safeguard and promote that child's welfare. We see that from section 22(3) and page 838. So then one asks, what is a court doing when it makes an order under the inherent jurisdiction, an order of this nature? And what the court is doing in our submission is the court is deciding whether it is lawful to deprive the child of liberty in the placement and in accordance with the care package being provided by the local authority. It is not conferring the power on the local authority to make that decision. The court is itself making a decision. The court is deciding whether it's lawful, and the court is deciding whether that deprivation of liberty is in accordance with Article 5 of the Convention. And we see what the court is doing from the template final order that is made in deprivation of liberty proceedings. And we see that from the decision, the case of Re AF number 2, which is in the bundle at tab 49, page 2625. This is the decision of Sir James Mumby as the second of a series of decisions he made in a number of test cases. And the order that the court makes in these cases, the template order, is set out at paragraph, we see what the judge was doing at paragraph 13, page 2630. There may be advantage in approving draft forms of order for use in these cases. I've prepared 3 forms of order which are attached to this judgment. That includes the initial directions, the order following the first hearing, and the order following the final hearing. And we see that at paragraph 18, which one finds at page 2636. So this is the form of order made following a final hearing. Sets out the parties in representation, it sets out the recitals, it refers to whether the child is Gillick competent or not. We see at 32 the parties are agreeing that the living arrangements and the care arrangements are such that he or she is being deprived of liberty. And then paragraph 33, either it appears to the court or the parties agree that the care and the living arrangements are in the best interest of the child and the restrictions on the liberty within that placement are necessary and proportionate to ensure their safety and ongoing welfare. And one then sees the declaration at paragraph 36. The child is deprived of liberty and unable to consent to the same. Paragraph 37, the court is declaring that it is lawful and in the child's best interest to be deprived of liberty by the local authority at the particular placement, and accordingly such deprivation of liberty is authorised until a particular date. And one also sees that paragraph 38, it's not a deprivation of liberty in the abstract that's been approved by the court. It's the confinement, the particular confinement that is described within the social worker's witness statement, which is in the particular place chosen as appropriate by the local authority. So it is approving or authorising the thing that the local authority already has the power to do by virtue of section 22C of the Children Act 1989. The appellant submits that this then places everything in the hands of the local authority, and it's for the local authority then to determine whether, for how long and to what extent those powers will be exercised. And we say that is not what the court is doing in this case. The court does maintain a review over what is occurring because we see from the actual body of the order, which is at paragraph 40 at the bottom of page 2637, if there is to be any change to the care or living arrangements, which are required as a matter of urgent necessity, which would render it more restrictive, the local authority must apply to the court for an urgent review of this order on the first available date after the implementation of any such change. If they're not required as a matter of urgent necessity but are proposed, the local authority must apply to the court for a review of the order before any such changes are made. If there is any significant change, whether deterioration or improvement in the child's condition, or if it is proposed to move the child to a different placement, the local authority shall apply to the court for a review of the order. And then there is the long stop review that the court sets in place in order to comply with Article 5.4, that the matter must be returned to the court for a review within a certain period. The maximum period that Sir James Mumby has set out in guidance is 12 months, but the court does maintain a much closer control over matters when the case is unpredictable or when measures are particularly extensive or things of that nature. And I've acted in a number of cases where the court has perhaps authorised the deprivation of liberty for a matter of weeks while certain issues are resolved, or a longer period, say 2 or 3 months, if there's likely to be a move or things of that nature. So that is what it is that the court is actually doing, and that, we say, demonstrates that the court is determining the matter and is not conferring authority on the local authority to do so. Second, we say that the purpose of section 102 of the Children Act makes it plain that it does not serve as a statutory bar as contended by the appellant. And when asked the question, what was it that Parliament was intending to achieve by section 102 of the 1989 Act? And we say that it was intended to prevent the use of the wardship jurisdiction or the High Court's inherent jurisdiction to undermine the new statutory provisions for compulsory intervention in family life. And each of the subsections in section 102 is directed to achieving that objective. And we say that is apparent from the background materials that are summarised at paragraphs 61 to 68 of our written case. That's at page 355. My lady, in the interest of time, I don't intend to go through those in great detail, but to highlight some particular points. But I do invite the court to read the relevant paragraphs of these documents carefully. The first is the review of childcare law, which is at page 4215. And one sees from that document, paragraph 2.4c, that before the Children Act, there were many different provisions leading to care, different sets of criteria, and different defects and anomalies with each of those. And what the aim of the reforms was to create a single system, a single test, and a single mechanism justifying compulsory intervention by the state in family life. review noted a concern about the increasing use of wardship because of the defects I've just identified, and noted that it would usually be only exceptional cases that would need wardship. There's a summary of the recommendations in Chapter 3, and then Chapter 15 of that review sets out the reforms and the grounds for compulsory measures, which we now see in Section 31 of the Act. And what it makes clear that WAM intended to do was to remove the particular power of the local authority to acquire parental rights over a child by resolution, which is what one had in Section 3 of the Child Care Act 1980. And that is in the Secretary of State Supplementary Bundle at tab 1, where one can see how a local authority could acquire parental responsibility as a result of its own actions and without passing the threshold for intervention that was now being proposed. So one of the key elements of the reform was to remove that power and to ensure that local authorities could not acquire parental responsibility other than when the threshold for intervention was met. And the review noted that it may be desirable for the inherent power of the court to commit a child to care and control of a local authority, simply in accordance with the welfare principle, would be removed, and the recommendation was made that the Law Commission would consider these matters in the context of the wardship jurisdiction as a whole. We then see at tab 111, page 4400, the government white paper that followed that, which made clear at page 4405, paragraph 5C, that the approach was to reform this ability of local authorities to acquire parents' legal powers and responsibilities. The transfer to the local authority of such rights should only be done by a full court hearing following due legal process, and the transfer must rest on establishing that the grounds for intervention were met, so the risk of significant harm, etc. One then sees the Law Commission's working paper on wardship. That sets out the circumstances in which wardship had been used historically. It set out a number of options for reform and invited proposals on that. And one sees in the conclusion at page 4521, that even if the current reforms, paragraph 3.52, under the heading conclusion, even if current proposals for reform of the statutory procedures are implemented, there would still be no alternative to wardship, or wardship might seem to offer significant advantages in a number of scenarios. And those are then all set out there, including at subparagraph 7 over the page, where a local authority wishes to invoke the jurisdiction for any reason. The next in the tail is the Law Commission's report on family law, which is at tab 114 and page 4546, where one sees at page 4550 what the Law Commission was recommending about the use of wardship. This is paragraph 1.4. Makes clear this report will be concerned only with the statutory powers of the courts to deal with the care and upbringing of children. We have decided to postpone making any substantial recommendations for the reform of the court's inherent powers in wardship proceedings. The response to our working paper indicated considerable support for some reform, but only once the statutory procedures in both private and public law had themselves been reformed. Our aim has therefore been to incorporate the most valuable features of wardship into our recommendations for a new statutory system. This should reduce the need to resort to wardship proceedings, save in the most unusual and complex cases. So it's plain that the Law Commission was recommending no change to the use of wardship in the inherent jurisdiction, at least until the reforms had settled in and had bedded down. One then sees the bill, the Children Bill, as it was introduced into the House of Lords at tab 115, page 4673. And one sees clause 21 is what became section 25, and clause 71 is what became section 100, and we see clause 71 at page 4738. And the explanatory notes that accompanied this bill when it was introduced into the House of Lords are found at page 4663. And the commentary on clause 71 is at page 4671. And this states that clause 71 prevents the inherent power of the High Court being used to put a child in local authority care or under its supervision, or otherwise to give local authorities compulsory powers in respect of a child. It requires before a local authority may otherwise invoke the inherent jurisdiction, then to obtain the leave of the court by showing the remedy they seek is not otherwise available, and that in its absence the child will suffer significant harm. The clause seeks to protect children and families from compulsory care or supervision, except where the statutory grounds for care exist under the bill, and in other cases to preclude intervention by local authorities unless harm to the child is likely. And one then sees from the Hansard debates that we've included in the bundle the intention of the introducers of the bill. One sees the first extract at page 4800, which is the Lord Chancellor in the House of Lords at the second reading stage. He's introduced in the bill part 3 of the bill, part 4 of the bill, setting out the new grounds on which the court will have to be satisfied before making care and supervision orders. And then one sees at page 4801, the third paragraph from the top. I must say a word about wardship. The government, in line with the Law Commission's decision to postpone making recommendations about wardship, have not sought in this bill to reform that area of child law as such, although many of the reforms should substantially reduce the need to invoke the High Court's inherent jurisdiction. There is one exception, however. The conditions in the bill which must be satisfied before the state, in the guise of the local authority, can intervene in families by seeking the following orders are carefully designed as the minimum circumstances which can justify such action. Accordingly, the bill prevents the High Court's inherent jurisdiction, which is not limited by such conditions, being used to confer compulsory powers on local authorities. It's recognised that the High Court would not be likely to exercise its powers in those circumstances. As a matter of principle, it is important for the law in a free society expressly to protect the integrity and independence of families, save where the significant harm test is met. And then over the page at page 4802, in the right-hand column, this is again the Lord Chancellor, but at the next stage of the bill, in the committee stage in the House of Lords. He says there appears to be a certain amount of misunderstanding about clause 71. Clause 71 does not proceed on the basis that the code in the bill is complete. Rather, clause 71 provides that the inherent jurisdiction of the High Court cannot be used as an alternative to a care or supervision order. That is what it says. It does not say that it cannot be used at all, but it cannot be used as an alternative procedure for a care or supervision order. The situation is that if one wants a care or supervision order, one has to satisfy the statutory criteria, and then the paragraph underneath that, there's nothing in that that restricts the wardship jurisdiction of the High Court, except to provide that it cannot be used as an alternative to these procedures. So it's making clear that the inherent jurisdiction survives the passing of the 1989 Act, but more importantly that the bar in section 102 is there to protect or prevent local authorities from acquiring care or supervision orders, or from acquiring parental responsibility in respect of a child, because the only way in which that can be obtained is through a care and supervision order. My lady, just to complete the Hansard references, one sees, when the bill then moves to the House of Commons, one sees the statement from the sponsoring minister there on page, it starts at page 4803. where again it repeats the phrase, the intention of, it had become clause 69 by that point. The intention of clause 69 is to prevent local authorities from using the High Court's inherent jurisdiction, including wardship, as an alternative to a care or supervision order, or as a means of their otherwise obtaining compulsory powers over children. We say that the inherent power remains available to cover circumstances not provided for in statute, but it is not to be available as an alternative to care and supervision, which is obtained in the normal way. And my lady, just to complete that section, there's a further reference at page 4805 in the right-hand column from the Solicitor General, who concluded the debate on behalf of the government. So, my lady, we say against that background, what was Parliament's intention in enacting section 102? And we say one has to look at what was repealed. If we go back to the language of section 100, which is at page 869, we see what was it replacing? Well, we see section 101 makes clear that section 7 of the Family Law Reform Act 1969, which gives the High Court power to place a ward of court in the care or under the supervision of a local authority, shall cease to have effect. What was also repealed was section 3 of the Child Care Act 1980, which we've already looked at. This is the assumption by local authority of parental rights and duties by resolution. So that was repealed because, again, the intention was that a local authority can only obtain parental responsibility for a child if it obtains a care and supervision order. And then when one looks at the text of section 102, we see that this is the mirror image of the provisions that are being repealed. So no court shall exercise the High Court's inherent jurisdiction with respect to children so as to require a child to be placed in the care or put under the supervision of a local authority, so as to require a child to be accommodated by or on behalf of a local authority, to make a child who's subject for care order a ward of court, so one can't trump the care order by making them a ward. And then the provision that we're concerned with, for the purpose of conferring on any local authority power to determine any question which has arisen or which may arise in connection with any aspect of parental responsibility for a child. So the local authority can't exercise parental responsibility for a child through the inherent jurisdiction. It has to have obtained a care or supervision order first. So we say that is the nature and extent of the bar in section 102. And the local authority cannot exercise parental responsibility for a child, save where it obtains parental responsibility under Part 4 of the 1989 Act. And we say, save for that statutory bar, the use of the inherent jurisdiction is preserved, subject to 100 subsection 3 to 5 of that Act, and we'll look at those in a moment. So, my lady, that's the second reason why the appellant is wrong on the first issue. And the third reason why section 102D is not a statutory bar in the circumstances of this case is that even if the appellant could establish that invoking the inherent jurisdiction conferred on any local authority power to determine any question at all, she cannot establish that any power conferred on the local authority is power to determine any question in connection with any aspect of parental responsibility for a child. So the simple answer is that parental responsibility does not extend to depriving a Gillick competent child of her liberty. And we say that follows from the recent decision of this court in Re D and applying the logic of the House of Lords decision in Gillick. So if a child is Gillick competent to consent to the placement or the arrangements for her care that amount to a confinement, then that does not fall, the confinement itself does not and cannot fall within the scope of parental responsibility. My lady, Gillick is in the bundle at tab 11, page 1174, and I've made various references to it in our written case. I don't propose to go through it now, and I intend to focus instead on your ladyship's judgment in Re D, but I do invite the members of the court to read those references in Gillick. But to turn up Re D, this is at tab 10 and page 1119. And as at least 3 members of the court may well recall, the issue in this case was whether a child who was not GILIC competent, as it was common ground that D was not GILIC competent, whether his parents could consent to the arrangements for his care so that it did not amount to a deprivation of liberty. And the issue in Re D, the central issue in Re D, is summarised at paragraph 3 of Baroness Hale's decision, Baroness Hale's judgment, which is at page 1125. Which says that this case is about the interplay between the liberty of the subject and responsibilities of parents, between the rights and values protected by Article 5 and the rights and values protected by Article 8, and between the relationship of parent and child at common law and the Convention rights. The principal issue can be simply stated: is it within the scope of parental responsibility to consent to live-in arrangements for a 16 or 17-year-old child, which would otherwise amount to a deprivation of liberty within the meaning of Article 5? And the ratio of the case is that the court said no, it is not, for a child who is 16 or 17. And the point at which all 3 members of the majority agreed was that a parent could not provide valid consent for the purposes of Article 5 and Limb B of the Stork test to what would be a confinement of a 16 or 17-year-old child. But each of the judgments go on to consider the nature of parental responsibility. The Secretary of State's position in Re D is summarised at paragraph 17, which is at page 1128. The first argument was about the nature of confinement, which does not concern us at present, but secondly, that even if a child is confined, a person with parental responsibility may provide a valid consent if the child is not GILIC competent. So the Secretary of State's position had always been that where a child is GILIC competent, then a parent cannot provide that consent as part of the aspect of parental responsibility. And Baroness Hale's discussion of parental responsibility starts at paragraph 19. She refers to my Lady Black's judgment at paragraph 21 and the discussion about common law concepts of parental power. She refers to the high watermark case in re Agar Ellis and the decision of the Court of Appeal in Hewer and Bryant. And she discusses how the common law had developed over time. Goes on to look at that decision, Hewer and Bryant, in paragraph 22. Discusses the case of GILIC at paragraph 23. And then refers at paragraph 28, which is on page 1132. The question is whether there are any limits to the general rule, and in particular whether it's within the scope of parental responsibility to make arrangements which have the effect of depriving a child of his liberty. In view of the conclusion I've reached as to the effect of Article 5 and the interaction between parental responsibility and the child's rights, it is strictly unnecessary to reach a concluded view on that question. But she acknowledged the force of the conclusion reached by my Lady Black at paragraph 90 of her judgment, and stated that it reinforced the conclusion which Baroness Hale had reached for other reasons. One also sees at paragraph 38 a discussion about whether a parent could consent to arrangements that fell within the scope of Section 25 of the 1989 Act. And she cites at paragraph 38 the Court of Appeal's decision in UK. And one sees between G and H, the President recognising the force of the principles in Nielsen. Nevertheless, there is a point at which one has to stand back and say, is this Section 25 restrictions within ordinary acceptable parental restrictions upon the movements of a child, or does it require justification? And then quoting from Lord Justice Judge to the same effect, in short, although normal parental control over the movements of a child may be exercised by the local authority over a child in its care, the implementation of a secure accommodation order does not represent normal parental control. And paragraph 39, Baroness Hale concludes that, as it seems to me, is the crux of the matter. Do the restrictions fall within normal parental control for a child of his age, or do they not? And the Section 25 secure accommodation order, the argument was that they do not. We see the ratio of the case is at paragraph 42, which is the conclusion that a parent can't provide valid consent for a child over the age of 16 and 17. But one then goes on to see further discussion of parental responsibility at paragraph 46, page 1138. And the last sentence of paragraph 46, is there any scope for the operation of parental responsibility to authorise what would otherwise be a deprivation of liberty? And Baroness Hale goes on to discuss that, paragraph 47, paragraph 48. The key conclusion for present purposes is paragraph 49. In conclusion, therefore, it was not within the scope of parental responsibility for D's parents to consent to a placement which deprived him of his liberty. So we say that supports the submission we made that parental responsibility does not extend to depriving a child over the age of 16 at least of his liberty. And Baroness Hale goes on at paragraph 50 to express provisional views about whether that would apply to a younger child whose liberty was restricted to an extent which was not normal for a child of his age. She notes that issue does not arise in this case, and the common law may draw a distinction between those who've reached the age of 16 and those who have not, and therefore preferred to express no view upon the question. The next judgment is that of my Lady Black. It starts at page 1139. We see at paragraph 51 that my lady agreed with Baroness Hale's conclusion that the consent of D's parents to his confinement cannot operate as a substitute for D's own consent for Article 5 purposes. And you agree with Baroness Hale's conclusions and reasoning for that conclusion, that there's no room for substituted consent. And you go on to say, my lady, that you make comments directed at the prior issue of whether it is actually within the scope of parental responsibility to consent to living arrangements for a 16 or 17-year-old child, which would otherwise amount to a deprivation of liberty within the meaning of Article 5. And the judgment goes on to discuss the an analysis of the historical case law, the Victorian cases on parents' legal right to custody, from paragraphs 56 to 68. My lady, at paragraph 69, you make the point that Gillick is not directly on point and that there are two important differences between Gillick and parental responsibility to deprive a child of liberty. We accept that, but we say that the approach in Gillick applies by analogy to this case, as in it identifies when parental responsibility for a child comes to an end. My lady, you consider the detail of Gillick from paragraph 73 onwards. I don't intend to go through that in detail now, but I do invite the court to read paragraph 73 through to paragraph 83. And then, my lady, at page 1150, that's where you draw the threads together and reach the conclusions. So the key paragraph at paragraph 88, as I've explained, I do not share the President's confidence that the Gillick test extends to the aspect of parental responsibility with which the present case is concerned, or that Gillick can, without more, be treated as regulating a situation where the objective is not to contract the boundaries of parental responsibility, but to extend them. And you explain why Gillick was different. But you then say, between E and F, I accept that certain things that were said in Gillick were capable of being interpreted as applying to a situation such as the present, but it's not appropriate to interpret them in that way so as to draw into the Gillick net a situation which is diametrically opposed to that which the House of Lords is concerned with, which the House was concerned with there. And you go on to say, it follows, between G and H, it follows that the rights of a parent in relation to restricting the liberty of a child remain at common law, as described in Hewer and Bryant. The inescapable result of that is, I think, that it is not within the scope of parental responsibility for parents to give authority for their 16-year-old child to be confined in a way which would, absent consent, amount to a deprivation of liberty. In so saying, I do not intend to in any way to water down the changes brought about by Gillick, etc. But then you go on, importantly for the purposes of this appeal, my lady, at paragraphs 89 to 90. The position in respect to the confinement of children who are under 16 might be different for a variety of reasons. It could be argued, for example, that the Gillick decision is more readily applicable to under 16s, given that this was the age group with which the House was concerned. My lady, I respectfully agree with that. It would then be arguable that the position in relation to that group was, as the President set out at paragraph 85 of his judgment, i.e. that the parental ability to restrict a child's liberty continues to be as described by Lord Justice Sachs and Hewer and Bryant, but with a Gillick test rather than the previous fixed ages. But the effect of this, applied to a child who lacked capacity, would not be to leave a gap in the parent's powers. On the contrary, the child not having attained Gillick capacity, there would be nothing to bring to an end the parent's common law power to confine the child as required in the child's interests. It would remain within the ambit or zone of the parent's parental responsibility. My lady, we adopt that. We say that when a child is Gillick competent, has achieved Gillick competence, it is no longer within the scope of parental responsibility for a parent to confine that child in circumstances that would amount to, that would satisfy limit A of the Stork test. So we say, regardless of whether the appellant is correct on the first part of her argument, it must fail at this second stage because it is simply not part of parental responsibility to deprive a Gillick competent child of her liberty. And my lady, just for completeness, I note that my lady, Lady Arden, agreed with Lady Hale on the ratio of the case, that parental consent is not effective to prevent a child being deprived of their liberty for Article 5 purposes. But at paragraph 121, my lady, Lady Arden, expressed no view on the common law issues that were discussed in my lady, Lady Black's judgment. Well, lady, that may leave certain issues to open as a result of the judgment, if we're right on this. There may well be issues as to whether parental responsibility extends to depriving a non-Gillick competent child of liberty when the child is under the age of 16. There may well be issues about what exactly the zone of parental responsibility means at common law. They do not arise; those issues do not arise for determination in this case. We say it is clear that when a child has achieved Gillick competence, then depriving them of liberty is not a part of parental responsibility. So, lady, for those reasons, though each of those three reasons, we say that the first issue must fail, and that section 102D is not a statutory bar to the use of the inherent jurisdiction in this case. I now want to turn to what was issue 3 in the appellant's submissions, that one cannot use the inherent jurisdiction to cut across a statutory scheme. Now, my lady, the premise for this submission is that both placements at the two homes in question were both children's homes and were secure accommodation for the purposes of Section 25 of the 1989 Act. Now, I think the court's already aware that there have been no factual findings on these points. There's disagreement between the parties as to whether the first was a children's home at all, and disagreement between whether either of the two provisions were in fact, or at law, secure accommodation. And I don't intend to address the court on the facts because the Secretary of State was not involved below, and that is not why the Secretary of State has intervened. But I do want to make submissions on the points of principle that determine these questions. And the first question for the court to consider under this issue is whether these placements were secure accommodation at all. Because if they were not, then there can be no question of these placements cutting across the scheme in section 25. Rather, they would fall entirely outside the scope of section 25, which is concerned only with secure accommodation. Now, this morning, it was said that secure accommodation is so expensive, it applies to any accommodation where a child's liberty is being restricted. That is, it is said, the touchstone of identifying secure accommodation within the scope of section 25. Now, as a result of Cheshire West, the circumstances in which children can be deprived of their liberty has extended significantly. So if the appellant is right in this submission, then in one fell swoop, there will be a significant expansion to the placements that will fall within section 25 of the 1989 Act. This is likely to cause significant difficulties. There may well be children, in fact, there will be a significant cohort from that group who do not meet the threshold for the grant of a section 25 order. If the appellant is right, they can no longer be deprived of their liberty. They can no longer be placed in the placements that are being identified by the local authority as best meeting their needs, keeping them safe and protecting them from harm. It would also mean that the creative alternative solutions to meeting the needs of children who have very complex requirements or very challenging behaviour can no longer be adopted. And the reason for that, if one looks at section 25 itself, which is at page 851, is that the threshold conditions for its use are that the child has a history of absconding and is likely to abscond from any other description of accommodation. So that means any other accommodation that is not secure accommodation. But if everything that restricts a child's liberty is secure accommodation, then there is no aspect of proportionality involved here, because the child, one would always have to find that the child is likely to abscond from any other description. There is no other description of accommodation that would be available. And the same for limb B, that if he's kept in any other description of accommodation, so anything other than secure accommodation, he's likely to injure himself or any other persons. So expanding the concept of secure accommodation, as the appellant has sought to do, would have very significant consequences. We say that is not the correct test. The test is not simply whether accommodation restricts a child's liberty. We say that the test for identifying secure accommodation is that suggested by my lady, Lady Black, in the Reedy test, in the Reedy case, and that was adopted by the Court of Appeal in Re B. And indeed, it's surprising that we're during the entire course of my learned friend's submissions, we did not look at those authorities at all, and he has not explained why it is said that those decisions were wrong. So, my lady, if we turn first to my lady's judgment back again in Re D, the discussion of secure accommodation starts at page 1151 and towards at about letter G. Does section 25 of the Children Act apply to living arrangements such as D's? That you then set out the text of section 25 and the various submissions that were made in the Reedy case. Paragraph 98, you did not accept the Secretary of State submission in that case, that the identification or the touchstone of secure accommodation was that which had been approved by the Secretary of State. But my lady makes the important point at paragraph 103 that the focus should be on the accommodation and the purpose for which it is provided, rather than upon the regime within the accommodation. And you set out the reasons for that in paragraph 103. The contrast of secure accommodation with any other description of accommodation can be read as supporting the notion that secure accommodation is a description of accommodation rather than a description of a regime of care. One then moves on to paragraph 110 at page 1159, where my lady set out or summarised the decision of Mr. Justice Wall, as he then was, in case of In Re C, detention medical treatment, and where the judge had to determine whether the clinic for the treatment of a child with anorexia nervosa was in fact secure accommodation within the meaning of section 25, refers to some of the earlier authorities that my learned friend took you to this morning. And he set out there that while I respectfully agree that premises which are not designed as secure accommodation may become secure accommodation because of the use to which they are put in the particular circumstances of individual cases, it does seem to me that the more natural meaning of the words provided for the purpose of restricting liberty is designed for or having as its primary purpose the restriction of liberty. And he goes on to conclude that this is a question of fact. And the conclusion he reached in that case is that it was not secure accommodation, and expressing the view that the purpose of placement of a child in the clinic is to achieve treatment, and the accommodation provides a structure for that treatment. The fact that there was a degree of restriction on the patient's liberty was an incident of the treatment programme, and the fact that steps could be taken to prevent the child from leaving the premises did not of itself render the clinic secure accommodation. My lady, at paragraph 112, you note that section 25 had not formed a part of the oral submissions in Re D, and it was dealt with by way of written submissions later, and it would be better that such issues as there were should be resolved in a case where the relevant facts have been found, so that the section can be interpreted with reference to a real factual situation. I respectfully agree, and we do not have that here, because the courts below did not have the benefit of your judgment in Re D, and they did not have the benefit of the Court of Appeal's judgment in Re B, simply as a matter of the timing at which these points were decided. My lady, your ladyship's conclusions at paragraph 113, set out at the bottom of page 1159. The exercise in which we have engaged has been sufficient to persuade us that section 25 is not intended to be widely interpreted, so as to catch all children whose care needs are being met in accommodation, where there is a degree of restriction of their liberty, even amounting to a deprivation of liberty. There is much force in the argument that it is upon the accommodation itself that the spotlight should be turned when determining whether a particular accommodation is secure, rather than upon the attributes of the care of the child in question. We entirely agree. Paragraph 114, your ladyship goes on to say that a restrained construction of the section is also justified by the fact that the section has a last resort quality about it. It's concerned with accommodation which has the features necessary to safeguard a child with a history of absconding or to prevent injury, etc. And your conclusions, my lady, at paragraph 115, of course, turning the spotlight on the accommodation itself does not provide a complete answer. Some secure accommodation will be readily recognisable from the fact that it is approved as such by the Secretary of State, but that is by no means a universal formula, as that approval is not needed for all types of secure accommodation. Moreover, given that it is contemplated that secure accommodation might be provided in places such as hospitals, it seems likely there will not infrequently be more than one purpose of the child being in the accommodation, and there is much to commend Mr. Justice Wall's approach to such a situation, that is, to count within the definition of secure accommodation, designed for or having as its primary purpose the restriction of liberty. And my lady, we respectfully agree with that approach and we adopt it. And it's important to note that on the facts of Re D, that was not secure accommodation. That was a residential unit funded by the local authority. Indeed, when the child in Re D was 15, one sees a description of the unit in which he was placed at page 3198 of the bundle, which is the judgment at first instance. And again, we would say that that is not secure accommodation. And one also sees the judgment at first instance once D had turned 16 and he moved placements. That is at tab 50 of the bundle, page 2639. And again, one sees the description of the placement, the residential unit in which he lived. And again, we say it's plain that that was not secure accommodation either. My lady, your ladyship's approach was adopted and applied by the Court of Appeal in Re B. That is at tab 16 in the bundle, page 1331. And the discussion of the meaning of secure accommodation starts at paragraph 46. And paragraph 51 is the key to the decision. Page 1355, the case law at first instance therefore supports the view that the meaning of secure accommodation is as defined in section 25. The focus is on the use of accommodation for restricting liberty. If the accommodation was designed for the restriction of liberty or the primary purpose of the placement is to restrict liberty, it amounts to secure accommodation. If there is a different primary purpose, for example, treatment, the accommodation will not amount to secure accommodation, even if there is a degree of restriction on liberty. Again, my lady, we respectfully adopt that observation. One then sees the conclusion, just for completeness for the court note, one sees the conclusion at paragraph 106 on page 1372 and paragraph 107. So how then does that test work in practice? We say that outside of the criminal justice sector, which does not fall in section 25, the only accommodation that is designed for the purpose of restricting liberty is accommodation that is a secure children's home approved as such by the Secretary of State. I've set out the details of how that secure children's estate is designed in paragraph 45 of the written case, so as to give an illustration of what that looks like, what features that accommodation has. It is more difficult, we say, to identify when the primary purpose of accommodation is to restrict a child's liberty, as opposed to providing a child with care and support or with medical treatment. But, my lady, we adopt the position that your ladyship took in Re D, which is that a significant number of children living in confined circumstances will be outside the ambit of section 25. That's at paragraph 91 of your ladyship's judgment. And that section 25 is not intended to be widely interpreted so as to catch all children whose care needs are being met in accommodation that amounts to a deprivation of liberty. We say that the criteria that one sees in section 25(1) indicate the kind of characteristics that one would expect to find in secure accommodation. So we say that if the primary aim of the accommodation is to keep the child safe, to prevent the child from absconding where they are likely to suffer significant harm, or to stop a child from harming him or herself or other persons, then it would satisfy the test for secure accommodation. We say that is likely to be the case only when existing placements have broken down in circumstances where the section 25 criteria are met, where the placement is a last resort placement after other placements have failed, and where the primary aim is to keep the child safe and stable before necessary therapeutic work commences. So one then looks at how this test can be applied across different settings. And we say it is highly unlikely that a foster care placement would ever amount to secure accommodation. We know that many foster care placements deprive a child of their liberty, and that was exactly the scenario that the Supreme Court was concerned with in Cheshire West itself. But the primary aim of such placement is likely to be to provide care to a child as a parent would. The primary aim is not to restrict the child's liberty. We say that it is unlikely that a placement in a hospital would amount to secure accommodation in light of RE-C. The primary aim of that of hospital accommodation is likely to be to provide treatment within, if necessary, a particular structure, perhaps of a locked ward. But the whole purpose of a child being in hospital is to receive treatment. Hospitals are not containment spaces, it's to provide treatment. And that submission, we suggest, is supported by the actual facts of RE-C when one looks at the environment in which the child was accommodated. We then say that it's highly unlikely. Toby, so before we move on to that point, one might gain some assistance from looking at the statutory definition of a hospital. I don't have that in the bundles, but I can provide it overnight if need be. But Section 275 of the NHS Act defines a hospital as any institution for the reception and treatment of persons suffering from illness. We see the definition of an independent hospital in Section 2 of the Care Standards Act, which is in the bundle, and it's defined as a premises where the main purpose of which is to provide medical or psychiatric treatment. That's a statutory definition of the main purpose. We also say it's highly unlikely that semi-independent or supported living placements would ever amount to secure accommodation, just by the nature of the support that is being provided. They're not supposed to be providing care, it's supposed to be support. It's highly likely that if a child's having their liberty restricted in such a placement, then it would in fact be providing care. And if it's providing care and accommodation, it is a children's home and it should be registered as such. We accept the test may be met in children's homes, but whether the test is met will always depend on a careful analysis of the local authority's primary purpose in placing the child. It will always, we submit, be part of the local authority's purpose to provide care and possibly treatment to the child. So one has to draw a distinction between whether the primary purpose of the placement is to provide care or treatment, with the accommodation providing a structure for that care or treatment to be delivered, or whether the primary purpose of the placement is to restrict the child's liberty, with the provision of care and or treatment to the child being secondary to that. And we say that the way in which this, if this is the right test, which we say it is, that those who have to operate the Section 25 and secure accommodation regime need to have practical guidance about how that regime works in practice and the kind of accommodation that is likely to amount to secure accommodation for the purposes of the Act. My lady, yes.
I wonder whether you've used two senses of the purpose of the accommodation. One is the purpose of the accommodation, and the other is the local authority's purpose in placing the child in the accommodation. I think you slid from one to the other in the course of that last series of submissions, and it may be significantly different.
It may, but when one looks at a children's home that is not a secure children's home, what is the purpose of that accommodation, the primary purpose of it? It is always going to be to provide care and support, possibly treatment, to a child. That's the purpose of the accommodation. Now,
but what about the placement which takes place simply because there isn't any approved secure children's home?
Well, then one has to examine what is the reason why that accommodation is being provided to that child. And I think what I was trying to make clear is that if the child is being placed in circumstances where the Section 25(1) threshold is met, that may well then be an indicator that it is a placement for the purpose of restricting liberty. But one has to be clear that it cannot be all children's homes where a child is being deprived of their liberty, because that would cover the vast majority of placements of children in children's homes. So it would just ride a coach and horses through the operation and application of Section 25. Yes, my Lady Arden.
Finished. I was
I
just
didn't hear the start of that.
I was simply saying I'd like to ask a question following on from Lady Black, if Lady Black would permit me, and that is that Lord Hope and Lord Clyde, in one of the authorities cited by my lady in her judgment D, were very clear that it was the accommodation, the physical accommodation, which had to have the purpose, not the local authority. But there was a good policy reason for that, namely it enabled people to determine very quickly whether this was in fact a secure home. It was a question of policy. And I wondered if your submissions were actually departing from that.
That certainly wasn't my intention, my lady, because the Secretary of State wants a scheme that is practical and workable for local authorities and others in this field to operate. But the primary submission we advanced to the court in Re D, which you may recall, was that the only accommodation that is secure accommodation is that which is approved by the Secretary of State. Now that, it was said, went too far, it was too stark an approach. So what we do say is that is the only accommodation that will be designed for the purpose of restricting liberty. One then has to say, how do you identify that accommodation which has as its primary purpose the restriction of liberty? Now, it is not in my submission an easy test to apply, but if one is to apply it, the only way we say in which it can be done is by looking at what is the purpose for which the accommodation is being used. Because if the test is not just designed for that use, then there must be accommodation which can, for certain uses, be secure, but for other uses is not. So one has to look at, we say, what is the primary purpose of that accommodation when that child is placed there.
Thank you.
Could I bring you back to Lady Black's question? And that is, if a judge decides that Section 25 criteria are met and indeed wants to place a child in secure accommodation, but there is no place available, what is the position then as far as the inherent jurisdiction is concerned?
Well, my lord, that was going to be what I was going to move on to from here, which is that setting up, what I've said so far sets up the structure of what is secure accommodation and what is not. And my submission is that if the accommodation with which the court is concerned is not secure accommodation, then it does not fall within the scope of Section 25 at all. There is no statutory bar on the use of the inherent jurisdiction. There can't be. The only test is whether the conditions in Section 103 to 5 are met, and that if the placement deprives the child of liberty, if the child is being deprived of liberty in that placement, then an authorisation is needed from the court so as to comply with Article 5. But what your lordship was asking me is that if the accommodation is secure accommodation, but the child cannot be placed in an approved secure children's home because there is no place, there is no vacancy, then we say that one can still use the inherent jurisdiction to authorise that placement. We say there is no statutory bar simply because there is no placement available, no vacant placement available in an approved secure children's home. And the reason for that, we say, is that it is a question of statutory interpretation whether Parliament intended to prevent the use of the inherent jurisdiction in circumstances where the placement is secure accommodation, but there are no approved children's homes available. And we say Parliament did not intend to do that because Section 100 of the Children Act expressly preserves the inherent jurisdiction, save where it falls within the statutory bar in Section 102. So I will take the court shortly to the cases on the use. My lady, yes.
I just wanted to ask you how that works with Regulation 3 of the regulations.
Yes. Well, my lady, what we say is that Section 25 was never intended to be a complete code so as to oust the inherent jurisdiction of the High Court. And we say it is clear that Parliament never intended that to be the position, both from the existence of Section 100 in the first place and the background materials that I've already taken you to in the context of Issue 1.
I understand that part of the submission, but it's the language of Regulation 3, which is on page E893, which at the moment I'm finding a bit of an obstacle to the child actually being put into the accommodation. Accommodation in a children's home shall not be used as secure accommodation unless it's been approved by the Secretary of State. Where we are at the moment in this submission is it hasn't been approved by the Secretary of State, but it is secure accommodation. It is a children's home.
That's right. But we say one cannot then obtain a Section 25, an order under Section 25 of the 1989 Act because of Regulation 3. But we say one can obtain an order authorising the placement of a child in a children's home that is not an approved secure children's home under the inherent jurisdiction. We say it was never the intention of Parliament that a child should be exposed and left to suffer harm simply because the child cannot come within the terms of the statutory regime that was set up in Section 25. That's what the inherent jurisdiction is there to do. It's there to fill the gaps, to fill the statutory lacuna in the best interests of the child.
But just focusing on the words of the regulation, how does it happen?
Well, in the way I suggested, my lady, that one cannot have an order under Section 25 because of Regulation 3. Accommodation in a children's home shall not be used as secure accommodation unless...
Yes, but just hold on a moment. We've just said that the definition of secure accommodation is not tied inextricably to approved children's homes. And therefore, it could still be classed as secure accommodation, even if it can't come within Section 25.
Yes, I say
the child be placed there.
I say the circumstances in which that would happen would be rare, but yes, I accept that it could in principle. I say what Regulation 3 does is say that the child cannot be placed there under Section 25. The court cannot make a Section 25 order. But one then goes to Section 100 of the 1989 Act. So the court can't the local authority can't make an application for the exercise of the inherent jurisdiction unless the authority has obtained the leave of the court. So the authority goes to the court and says, can I have permission, please, to invoke the inherent jurisdiction? The court may only grant leave if it's satisfied that the result which the authority wished to achieve could not be achieved through the making of any order of a kind to which subsection 5 applies. And that's any order made otherwise than in the exercise of the court's inherent jurisdiction and which the authority is entitled to apply for. well, the authority would be entitled to apply for Section 25 order, but can't get one because of Regulation 3. So one then comes back and says, well, the local authorities met the first condition in 104A. And the second condition is there reasonable cause to believe that if the court's inherent jurisdiction is not exercised with respect to the child, he is likely to suffer significant harm? And we would say in that situation that yes, if the child needs secure accommodation, that is the local authorities say he will suffer significant harm if he doesn't get it in a children's home, then that section entitles the High Court to exercise the inherent jurisdiction to authorise the placement of a child. Now, we say that has to be done in a way that doesn't cut across the statutory framework. So that would have to be done only in circumstances where the threshold, the Section 25 threshold, is met. But it can be done, and the reason why it can be done is because that is what the inherent jurisdiction is there for. It is there to protect children where otherwise they would suffer significant harm in circumstances where the authority cannot obtain the order it otherwise needs under the statutory framework.
Thank you very much, but I think Lady Arden had a question.
It's just a supplementary, which I thought might be of some assistance, and that is that the definition of secure home makes it clear you haven't got a secure home unless the child is a child to whom Section 25 applies. So that leaves out of account altogether the other children we're discussing. Now, I appreciate that's not every case, but those children will not actually be involved in Section 3, in Regulation 3, because the home is not a secure home so far as they're concerned.
Yes.
That's Regulation 2, I think, that Lady Arden's looking at, is it?
On the same page, just higher up.
Yes, I'm sorry, I was looking at Regulation 3 and couldn't see what your ladyship was saying. Yes.
It's got the definition of secure home.
Yes. My lady, I see that. Yes, I would adopt that.
Yes, so it's inevitable that there are children for whom the qualities of a secure home are needed, but who are outside Section 25, and for them there can be no question of Regulation 3 creating an offence. Right?
Yes, I would agree with that, my lady, but it doesn't create an offence at all. It's not an offence to place a child in secure accommodation in a children's home that hasn't been approved for use by the Secretary of State. It's simply that the court under Section 25 has no power to do it. It is a children's home, a registered children's home is still registered as such. It's not an offence to operate a children's home as secure accommodation.
Yes, but you can't use...
It hasn't been approved. I'm terribly sorry.
No, I interrupted. I do apologise. I thought you had finished. You can't use Section 25. Sorry, you can't use the inherent jurisdiction to get round Section 25. That would be outside Parliament's purpose.
Well, it depends what you mean by get around Section 25. You can, in my submission, use the inherent jurisdiction where it is necessary to prevent a child from significant harm in circumstances where an order under Section 25 can't be obtained. But what you can't do, you couldn't do it the other way around. You can't place a child in a secure children's home when the conditions in Section 25 are not met, for example. That would cut across the framework of Section 25.
Well, I was just suggesting to you that that might be possible under the inherent jurisdiction, but that actually you couldn't use the inherent jurisdiction where you did have a child who fell within Section 25, but for whom there was physically no place.
Well, my lady, that is a common situation where the inherent jurisdiction has been used.
I appreciate that.
We say quite properly so, because that child needs to be protected from the significant harm that would otherwise befall them were a Section 25 secure accommodation order not available. And it really comes back to this. We're asking here, what was Parliament intended to do when it enacted Section 25? Now, in some cases, and De Keyser, for example, where Parliament has enacted legislation that covers the field that was previously occupied by the prerogative, then the presumption will be that one can only exercise or one can only perform that function in accordance with the statutory provision. But the reason for that, we say, is a question of statutory interpretation. Where the Act of Parliament is silent or says nothing about the preservation of the prerogative power, then the necessary implication is that the legislation has ousted the operation of the prerogative. And I'll take your ladyship to the various provisions in De Keyser that I say support that in a moment. But here, what we have is very different. This is not an act where Parliament was silent about the continued operation of the prerogative power, i.e. the inherent jurisdiction. We look at all the background material, we look at the terms of Section 100 itself. The only statutory bar on the use of the inherent jurisdiction is that in Section 102. Otherwise, if a local authority can satisfy Section 103 to 5, if those conditions are met, the inherent jurisdiction is available. So the power under the inherent jurisdiction to authorise the deprivation of liberty of a child, to authorise the detention of a child, is not excluded or abrogated by Section 25 of the Act. Now, if one can get an order, and if one falls squarely within the terms of Section 25, and the court can make an order placing the child in a secure children's home under Section 25, of course one must go down that route first. But if the threshold for Section 25 is met, but one comes with a situation where a child is in desperate need of placement to protect them from significant harm, in some cases even to preserve their life, we say it was never Parliament's intention that the court take hands of that and say, we're terribly sorry, we can't use our residual powers, our inherent jurisdiction to protect that child because you don't fall within the terms of Section 25. That was never what Parliament was intending to do when it enacted Section 25 and Section 100 of the Children Act.
Ms. Clement, I'm going to let you get on again in a moment, but this is an important area, and it might be thought that what Parliament was intending when it enacted the Children Act and associated regulations were made was to regulate secure accommodation by means of Section 25, and that there would be sufficient approved secure accommodation places to accommodate children. In other words, it wouldn't have been in contemplation that the inherent jurisdiction would be used for this purpose.
Well, my lady, that may well be the case, but what we're looking at here is an act that was passed in 1989. We have any number of cases, first instance judgments, where it's made clear that approved secure children's home is not what these children need. There are some cases where that is what the local authority is seeking, and unfortunately there are not vacancies at that particular point in time for that particular child. But there are other cases of children with ever more complex needs or ever more challenging behaviour, where secure children's homes are saying this is not the place for them, or local authorities are saying this is not the place for them. And so there needs to be an alternative placement for them, which may well be in a bespoke and specialist children's home. So it's not just the case that there are not enough secure children's homes, not enough beds in approved secure children's homes. There are other children with very complex needs, of whom the local authority in this case would say the appellant is one, whose needs could not be met in a secure children's home, and whose needs can be met in other children's homes that are more tailored to the individual's particular needs, where there are bespoke packages of care that are put in place. And if, I say, Parliament did not intend that those children's needs cannot be met, because the only option, if it is secure accommodation, is that they can be placed in a secure children's home. And my lady, you'll have seen the description of a secure children's home that I've set out in our written case. And it's my submission that those are clearly not environments that are going to meet the needs of all of these very complex children. What we do want, what the Secretary of State does want, is for the placements where those children are, the placements made for those children to be registered, and so that they are subject to the statutory safeguards that are set out in the Care Standards Act. Those are the proposals that the Secretary of State has been consulting on very recently. You have those in the bundle about means of securing improved registration of these provisions, making it clear out to local authorities what accommodation needs to be registered so that they can go on and work with the care home providers to get them registered. But secure children's homes are not necessarily the answer or the only answer to meeting the needs of these children. And we say Parliament cannot have intended that their needs can only be met in that setting. My lady, I'm conscious of the time. How late are you prepared to sit today?
We really, I think, probably need to finish at around 4:30, but you missed out on 20 minutes beyond that, because we started, I think, at 10 to 3. So I would propose that is, if everybody's able to sit at 10 o'clock tomorrow, we could do it that way, and you could then resume tomorrow to finish off the 20 minutes. Would that, we've asked you a lot of questions, I've asked you a lot of questions, would that be sufficient time?
I would hope so, yes. I'm hoping to make a little headway in the 10 minutes left to me this afternoon. I may well do it by way of giving, dare I say, a suggested reading list for before tomorrow morning, just simply some of the references I was going to take the court to. But I would hope to at least finish this point this afternoon, so that I can come back tomorrow with to deal with Article 5 and to make the few observations I want to make about the role of consent.
And I think that everybody was all right with starting at 10 o'clock tomorrow, if that's the way we do it. Yes. Okay.
I'm very grateful. My lady, in terms of the references I wanted to give, some of those were to references to De Keyser to make the point that this is all a question of statutory interpretation, whether Parliament entering a particular field has abrogated the use of prerogative power. We say that where legislation says nothing about the preservation of the prerogative, then it is a necessary implication that legislation has ousted its operation. But that is not this case. And if I just give the court the references, De Keyser is in the bundle, tab 9, page 1045. We see the judgment of Lord Dunedin starts at page 1063. And I'd invite the court to read page 1064. Lord Atkinson's judgment is at page 1076. And I invite the court to read page 1082. Then the judgment of Lord Palmer starts at page 1112. And so it doesn't start at 1112, but I'd invite the court to read 112. And in particular, at the bottom of page 1112, just looking at it now, it would be an untenable proposition to suggest that courts of law could disregard the protective restrictions imposed by statute law where they're applicable. In this respect, the sovereignty of Parliament is supreme. The principles of construction to be applied in deciding whether the royal prerogative has been taken away or abridged are well ascertained. It may be taken away or abridged by express words, by necessary implication, or where an act of parliament is made for the public good and not to prevent injury and wrong, etc. But what I say is different here is that Parliament was not silent on the feature of the inherent jurisdiction. What they dealt with the question expressly under section 100, and the only statutory bar is that in section 100 subsection 2. And my lady, the way in which this has been interpreted by the courts, there are 3 judgments I would invite the court to read. The first is the judgment of Mr. Justice Baker, as he then was, in the Health Service of Northern Ireland. This is at tab 51, page 2675. And I'd invite the court to read the head note and paragraph 16, which is at page 2682. It is well established that the High Court may, in appropriate circumstances, use its inherent jurisdiction to supplement a statutory scheme. The description of the common law as the great safety net, which lies behind all statute law, capable of filling gaps left by that law, if those gaps have to be filled in the interests of society as a whole. And one sees the correct approach summarised by Mr. Justice Roderick Wood in the vulnerable adults cases. Consistent with long-standing principle, the terms of the statute must be looked at first to see what Parliament has considered to be the appropriate statutory code, and the exercise of the inherent jurisdiction should not be deployed so as to undermine the will of Parliament as expressed in the statute. But one looks there at the statute includes section 100. And the next case is the Re X and Y case, which is at tab 13, page 1282. And I'd invite the court to look at paragraphs 37. And Terry, sorry, paragraph 28 first. Where the then President set out that it's clear that a judge in England cannot make a secure accommodation order under section 25 of the Act if the child is to be placed in a unit in Scotland. And that was before the various provisions were amended, but there was a statutory bar. And he sets out the reasons for that. On the face of the statute, the power extends only to secure accommodation in England, and that secure accommodation in Scotland is not approved by the Secretary of State in accordance with Regulation 3 of the 1991 regulations. So that's exactly the case we have here, placement in a children's home that's not been approved by the Secretary of State. One then sees at the discussion at paragraph 31 of the use of the inherent jurisdiction, where the President says, there being no relevant statutory power, I turn therefore to consider the inherent jurisdiction of the English High Court. And one sees, he goes through some of the case law that we have looked at. Paragraph 35, he cites section 100. And one sees at paragraph 36, I reject the submission that the existence of the statutory regime under section 25 of itself suffices to take the case outside section 104. The order which the local authorities applying for in a case such as this is an order authorising the placement of a child in secure accommodation outside the jurisdiction. That is not a result which the local authority is able to achieve by means of an order under section 25. That's exactly the same as the position in this case. Nor does it make any difference that the local authority would not be seeking to have recourse to the inherent jurisdiction, but for the absence of a place in a secure unit within the jurisdiction. The fact is that for whatever reason, the local authority is seeking a result which cannot be achieved by any means other than the inherent jurisdiction. And that would be exactly the situation here. Sir James then discusses at paragraph 37 onwards, and these are the paragraphs I'd invite the court to read carefully, paragraph 37 through to paragraph 45. He discusses the principle that we've been looking at from De Keyser, that the well-known and long-established principle that the exercise of the prerogative and the inherent jurisdiction is an exercise of the prerogative is ousted by any relevant statutory scheme. He sets out the decision, or summarises the decision from Mr. Justice Baker that I've asked the court to look at in the Health Service of Ireland case. He then moves on at paragraph 39 to discuss the decision of the House of Lords in De Keyser, and he discusses the vulnerable adult jurisdiction. He cites here some work from, I believe, Mr. Tumo's junior, Mr. Alex Lang, at paragraph 41. And he says at the end of that paragraph 41, it suffices for present purposes to note his proposition that if one or more of the gateway criteria cannot be met, use of the inherent jurisdiction is in principle permissible. He then cites the decision in Re C, decision in Re B, which I will come back to in a moment, and then the conclusion at paragraph 45. I propose to follow the same approach that has commended itself down the years to Mr. Justice Wall, to Judge Wildblood, to Mr. Justice Kean, and to Mr. Justice Bodie. It is an approach which, in my judgment, falls comfortably within a proper application of the principle expounded in the De Keyser's case. Section 25 does not, to use Lord Dunedin's phrase, cover the whole ground. It is not, in contrast to the legislation being considered in B and 4Z, a comprehensive statutory scheme intended to be exhaustive. To have recourse to the inherent jurisdiction in a situation as here, wholly outside the territorial ambit of the statute, does not cut across the statutory scheme, nor would it be incompatible with the statutory scheme. And then the conclusion at paragraph 47 and 48, it follows in my judgment that in principle, a judge in exercise of the inherent jurisdiction can make an order directing the placement of a child in secure accommodation in Scotland. And it goes on from there, saying that if the order places the child involves the deprivation of liberty and thus engages Article 5, the judge must ensure that both the substantive and the procedural requirements of Article 5 are complied with. And my lady, that is the approach we say should be taken in this case. Where one needs to be careful is to ensure that the exercise of the inherent jurisdiction does not cut across the statutory scheme. And we say it would only cut across the statutory scheme if what was being done was placing, for example, a child in a secure children's home when the threshold conditions in section 25 are not met. That would be directly contrary to the statutory scheme. So you can only place a child in an approved secure children's home if the conditions in section 25 are met. So one could not do that. One cannot place a child in a secure children's home if one of the threshold conditions are not met. One cannot, we submit, place a child under the age of 13 in a secure children's home without the approval of the Secretary of State. And one cannot do what the court was asked to do in the case of A City Council against LS, and this is at tab 47, page 2601. And this is the decision of Mr. Justice MacDonald. And one sees the local authority wish to place a 17-year-old child in secure accommodation since it considered him to be at risk of significant harm, various involvement in gang activity, etc. But the court had no jurisdiction to make an order under section 25 because the child was not being looked after by a local authority. So one of those threshold conditions for intervention was not met. There was no prospect of that situation changing because the child could not be made the subject of a care order since he was too old. He could not be accommodated by the local authority under section 20 since his mother objected to such a course. Despite that, the local authority applied for an order under the inherent jurisdiction, authorising the placement in secure accommodation. And Mr. Justice MacDonald, we say quite rightly, refused that application because one cannot put a child into secure accommodation when the threshold conditions in section 25 are not met. Because that would be completely counter to the scheme set out in section 25. But what one can do, what the court can do, is when the conditions in section 25 are met to place a child in secure accommodation, one can exercise the inherent jurisdiction to do that, to make that placement in secure accommodation other than in a secure children's home where that is necessary or thought appropriate.
I'm looking for a convenient moment for
Yes,
you.
that may well be it.
That might be it?
It might, yes.
Yes, okay. Well, thank you very much indeed. We will start again at 10 o'clock to make sure that we've got sufficient time to get through. I think you've got an extra 20 minutes to go tomorrow morning.
I'm very grateful. I will reduce things down as much as possible overnight.
Thank you very much indeed.
Thank you.